Good.
Good evening, everyone.
Good evening.
All right, let's see. We have a quorum. We have a small quorum, but at least we got one. Um, we can begin. Good evening, everyone. Thank you for joining our Operations Management Budget and Government Accountability Committee meeting for today, September 18th, 2023. My name is Councilman TJ Clark. I'm the majority leader for the City Council and also the co-chair for the OMBGA committee. And we are streaming live from HPA-TV.org at Hartford Public Access TV. We are doing streaming from channel 96 on Comcast, Xfinity, and 6032 on Frontier. We have a very small agenda, which is uncommon for this committee mostly, but I'm joined by Councilwoman Shirley Surgeon, who is not a voting member of the committee, Councilman Amelka Hernandez, who is a voting member, and Councilwoman Tiana Hercules, who is a voting member as well. And we are joined by our Corporation Counsel, Howard Rifkin, who has been with us for how many years now, Howard? 8?
It was only one.
He reminds me he only was supposed to stay on for 1 year, and look, it's been 8 years, so which is fantastic. Moving on, we have two items, as I mentioned, on our agenda. We also have Aaron Howard, who was our Director of Economic Development and Planning and Zoning, and Julian Fruing, who is our Director of Management and Budget. Item 1, which is Mayor Bronin with a company resolution authorizing the city to accept and deliver an agreement with wireless carriers AT&T and Verizon for the deployment of 5G in public rights of the way in the city. And Howard, are you going to be speaking? All right.
I'll start. Thank you, Mr. Chairman. Let me first introduce two individuals who are joining me on this issue. Retired Judge, Superior Court Judge Robert Holzberg. He was brought in by the governor's office to mediate an agreement between the wireless carriers, specifically AT&T and Verizon, and the cities of Hartford, Stamford, Bridgeport, New Haven, and Waterbury around the deployment and rollout of 5G technology in municipal rights of way. I know that's a mouthful, but that's and for the last year and a half, we've been meeting and trying to hammer out an agreement. And what is before you tonight is that outline of the agreement that was mediated by Judge Holzberg. Also joining me on this issue is Aaron Howard, who you all know, our Director of Economic Development. And Aaron has been involved in the issue of 5G, both from a regulatory zoning perspective, as well as from a policy perspective. And that goes back probably 5 years, maybe, around the time that the FCC issued a declaratory ruling. So I'm going to start, if I may, with just a general outline of how we got to where we are. I'll ask Judge Holzberg to add to that commentary, and then Aaron, and then we can discuss in as much detail as the committee wants the elements of what is in the proposed agreement for your consideration. So starting off at the beginning, in 2018, the FCC, the Federal Communications Commission, issued a declaratory ruling for the rollout of 5G nationally. And among the elements that were part of that ruling included preemption of state or municipal action that would in any way impair or interfere with the rollout of 5G. The declaratory ruling established specific timelines for state and municipalities to respond, consider, and act upon applications for the deployment of wireless devices. Those are called shot clocks in the vernacular of the FCC. It also caps fees that can be levied or charged both in the permitting process, the maintenance of devices in rights of way, and any other administrative costs that might be imposed by the state or a municipality. It did require, the ruling did, adherence to health standards, for example, radio frequency emissions standards, and all public safety standards, which I'll get into in a little bit. In 2022, the FCC also adopted an equity action plan, which establishes that a goal is to, quote, advance equity in the provision of access to digital communication services and products for all people in the United States without discrimination on the basis of race, color, national origin, sex, or disability. In part because of the number of issues that emerged and arose in a number of municipalities after the FCC order, including Hartford, the governor's office, as part of its 5G initiative and the establishment of a 5G task force that was created to advance 5G deployment, the cities of Hartford, Stamford, New Haven, Bridgeport, and Waterbury were asked by the governor to participate in a mediation with AT&T and Verizon, as I just mentioned before, to attempt to establish a common framework for 5G rollout and deployment in municipal rights of way. We agreed, as did Verizon and AT&T, and retired Superior Court Judge Robert Holzberg was hired through the governor's office as the mediator in the process. This effort has been a year and a half, Judge Holzberg, I think, in the making, and the agreement before this committee and council, which is outlined in a very detailed term sheet that you all were provided as part of the transmittal of the resolution and the agreement, does establish that common framework I spoke of, and is consistent with the FCC ruling. Plus, in addition to that, details all the responsibilities that the carriers have, including indemnification of the cities. And in the case of Hartford, adherence to our current zoning regulations, responsibility for repair, maintenance, construction, etc. And it does set out the fees that the city can charge, which is all consistent with the FCC ruling, among other things. And we can get into more details. That's just the general outline. We all of the named cities are submitting the proposed agreement to their respective legislative bodies. I think Hartford, this meeting today may be the first of all of the city's meetings to date, but I'm not totally sure, but I think that's the case. With that, let me just first ask Judge Holzberg to offer any commentary to create context and a richer understanding, and then I'll ask Aaron to comment.
Sure. Thank you very much, Attorney Rifkin and Councilman Clark and other council people. Thank you for the opportunity to speak with you tonight. As Howard mentioned, I can have take the liberty of calling him Howard, as I think you do. I was a judge for 23 years on a Superior Court, and in 2012, I came over to my present job at Pullman and Comley. I'm just around the corner from you, where I do mediations and arbitrations. And actually, it was 2 years ago that I received a call from the governor's office, almost 2 years to the date in September, asking if I'd be interested and potentially available to try to work with the cities and the carriers to try to hammer out an agreement. And as Howard mentioned, the genesis of that is that the 5 major cities, 3 5G carriers, and what was necessary, the governor's office thought, and I think we all agreed, is to try to devise a uniform process so that, for example, when AT&T goes to Hartford, it would more or less have the same set of rules as would Waterbury, Stanford, etc. There was a lot of inconsistency in terms of requirements. And so we set about the task of trying to come up with a common sort of plan, if you will, recognizing that some of the cities like Hartford have their own zoning rules and those have to be recognized. One of the important issues that we discussed at length and throughout the process had to do with this notion of preemption, which Howard mentioned to you. When I taught law school many, many years ago at UConn, we discussed this doctrine. I used to give the young law students the following example. It's an imperfect one, but bear with me. So imagine driving down the interstate highway, I-95, I-84. There are 4 lanes of traffic. The federal government has control over the construction of the highway, has control over the speed, has control over the repairs, it has control over the tolls, if there were to be any, has control over the entire process, so to speak, in the framework. But at the top of the exit ramp, the cities or municipalities are allowed to decide whether they want to have a stop sign, or they want to have a yield right of way sign, or they want to have a traffic light. And that sort of very, very limited role that the local municipalities have is what is meant when we talk about preemption. It's the federal law that really occupies all the space and that drives this conversation. And so there's some, but very little room for the municipalities to be involved in this process. And as Howard pointed out, that has to do with areas of aesthetics, fee setting, and the like on rights of way, which in this case really refers to city-owned telephone poles. There may be other structures, but throughout the process, we've really been talking about city-owned poles. So we've worked very hard and cooperatively. If I might take this opportunity, actually, I meant to say this at the top, to thank Howard and his team and Jim Del Visco from the planning office, who really, really did a superb effort of trying to come up with language and concepts that would be agreeable, not only to the carriers, but to the other cities. So because we need to get 8 signatories on this agreement. And so after a lot of work, after a lot of trading of drafts, after over 25 Zoom and virtual meetings, we met at the governor's office last month or the month before to try to have a final session to hammer out the remaining details. And we were successful, and this agreement is now before you as it is before all the other municipalities. Howard is right. You were the first to go, but Stanford, Waterbury, New Haven are lined up, and they're going to be submitting the same proposal with some minor variations to their legislative bodies as well. One of the important topics that we talked about and that has driven both the governor's office and all the parties has to do with the digital divide. That is, the opportunity for underserved communities to have as fulsome access to 5G as other communities. And of course, this is a very important topic. We spent a lot of time on this. The bottom line is ensured that under the federal law, the municipalities don't have a lot of negotiating power on this because it's covered by the federal law and the preemption that Howard described. But we did what I think is a fair and reasonable job in getting the carriers to recognize this obligation and try to move forward cooperatively with you in your leadership to make sure that all members of the community hopefully will have an opportunity to have access to this important technology. And that's reflected in the agreement. There are no specific covenants that you can sue on to say to AT&T or Verizon, you haven't done this or that, but there is an understanding sketched out in the agreement itself that this is a critical area that's of supreme importance. I can't think of another word for all the municipalities, and the carriers recognize this. The governor has endorsed this pathway forward. I think, given all the difficulties that we face, all the challenges, all the moving parts, all the personalities, the different political concerns of each of the communities, and the concerns of the carriers, that this is a fair agreement. And as I often tell the mediation parties, no agreement is perfect. There's always compromise. I know you know that from the jobs you do. You're always involved in trying to work out deals and make agreements. And I always subscribe to the view that don't let the perfect be the enemy of the good. I think this is a good, fair, and solid agreement. Howard, I'm happy to address any specific questions that you and your colleagues may have, or speak further if you think there are other points that I should highlight.
Let me first ask Erin if she has any additional comments she wants to offer before we entertain questions from the committee.
Sure. Thank you, Howard. I think the only thing I would add is just really demonstrate to council that this really was a 5-city effort for years in the making. And it really was an opportunity for us to work collaboratively, address the needs of urban cities and support our rural communities around us in a way that treated the deployment of 5G equally and fairly across the state. So this result of the mediation came of years of that. And it was just a great example of us collaborating. So thank you. And thank you to Judge Holzberg and Howard to take it over the line this past year and a half to really work hard on behalf of all of the cities to come to this agreement.
With that, Mr. Chairman.
Thank you, Howard, and thank you, Judge Holzberg, for your work and getting it to this point. I do remember when this first came about on the council, so it's been really such a long time. Reading through the cover letter and everything, are there access points where these I would say towers, I may not be using the appropriate language, where they're going to be placed? And I think that was somewhat of a concerning to some of these advocacy individuals regarding where they're going to be placed, if they're going to be placed in more of a higher populated residential area, one side of the city versus the other. Can you provide any type of details regarding that?
Sure. I think I'll start. First of all, it's important to understand that this agreement is limited to placement of wireless devices, which are really nodes on poles and other surfaces, and is limited to the rights of way of the city of Hartford. So, for example, if you go out into most of the neighborhoods in Hartford and see telephone poles that are owned by Verizon, this agreement does not include placement of wireless devices on those poles. That is within the jurisdiction of PURA. And the city has no role to play in that process. There are notification provisions that, for example, a homeowner or somebody in a commercial enterprise that where one of these wireless devices is going to be placed has to be noticed that there is an intent to do that and there is a process, but that's all under the jurisdiction. What we're talking about here again, are the placements of these small devices on rights of way of the city, mostly light poles that the city owns, and maybe some stanchions that come off of those light poles that are also owned by the city. So that's one thing. In our agreement with the carriers, there is a provision that says, and I don't recall what the time frame is, but it's pretty short. The carriers have to, within 30 days after the signing of the agreement, the carrier will submit to the city a non-binding plan consisting of a map identifying the number and potential locations of these small wireless facilities that the carrier may deploy in the initial 2 years of this agreement, and then details regarding necessary equipment, fiber optic extensions, etc., projected date ranges for permitting and construction, and that this notice is intended to afford the city with the opportunity to assess our staff needs, construction activity at the various sites, the possibility of the need to consider co-location of equipment on one pole. So if the Verizon plan and the AT&T plan target the same pole in, let's say, downtown, this would give us an opportunity to consider what it would mean if we got an application by both carriers on one pole. So those are the kinds of things but again, that would only apply to the rights of way that are part of this agreement. I don't know if that sufficiently answers your question, TJ, but let me also add one other thing. So the FCC ruling specifically in this regard is about rights of way in municipalities, in this case, with this agreement. If the wireless carriers want to deploy these small facilities in the neighborhoods on poles that are owned by Eversource or in New Haven UI, they would go through Pure as a process. If we were talking about, for whatever reason, some tower, which has really been the technology heretofore, but the 5G technology, it doesn't lend itself to having towers that have a great distance between them. But if we were talking about placement of a tower, that would be within the purview of the Connecticut Siting Council.
Thank you. I was wondering how the Siting Council played a part of that.
Yeah. So for example, there is actually a intent for, I think it's Verizon, to site a mini tower on a building that's owned by Trinity College. And there was specifically an issue about whether or not the city could impose design standards that are suggested in our zoning, or that are required in our zoning regulations. And it was clear from a previously decided Superior Court case that the Siting Council really had preemption there, and that it was in their control and responsibility for making those determinations.
Okay, thank you. Councilwoman Hercules.
Thank you. Through you, I just had a quick question about the deployment plan in replacing the current tower. So my understanding is the 5G replaces the large cell towers. So as these are deployed throughout the city, will those big, kind of obstructive towers be removed, or will they just become obsolete and still be there, but not in operation?
I don't think that the immediate future will make obsolete the existing tower. I mean, that 5G rollout is going to take a number of years, and I am not sure that until most recently, for example, 3G technology has been shut down. So wireless carriers no longer support that. Phones can no longer connect to a 3G network. If you have a flip phone from 10 years ago that was connected to 3G, it doesn't work anymore. 4G technology is such that it does allow for transmission between towers that are, maybe miles apart. And I don't think that's going to become obsolete for maybe more than a decade.
All right, thank you.
Yeah, probably longer than that. When you think about how long 3G was active. So.
Well, by the way, Howard, flip phones are coming back, just in case you're interested.
Well, good. I look forward to that.
Yeah, there is a brief conversation about this, and the reference point was New York, which is, sort of its own sort of city, and of course there's been massive deployment in the large urban areas, but those towers are still there, even though almost every telephone pole or stanchion in New York City now is some type of 5G device. But as I recall the conversation from the carrier's point of view, those large towers are going to remain in effect for a period of time.
Yeah, and until 5G, 4G is shut off, and you will not be able to use a phone that is only connected to a 4G network. Those towers are going to be necessary to provide wireless service.
Thank you. Councilman Hernandez.
Thank you, Mr. Chair. I have a follow-up question on the potential locations, the right of way. Were there any conversations on specific limitations on specific areas? Although, let's say that, as you mentioned as an example, let's say light pole, that's owned by the city. That qualifies under the right of way, so that is a potential location for one of these devices. If this light pole happens to be right next to a school, were there any conversations about not having these devices so close to the school or hospital or some of those places where we have number of children or people congregated at the same time throughout the day? Although I know and I understand that the agreement calls for carriers to follow the FCC, regulations. There are sectors of the community that are still a little bit concerned about, these devices and the potential, environmental radiation, and there are some studies, that speak to that. So were there any parameters that were established during this agreement to say, okay, it's okay the right of way, but there are some exceptions, yes.
So I'm sorry to cut you off. Go ahead.
No, go ahead.
Okay. So let me just read from the agreement. In addition to the requisite information, and this is in the term sheet, the detailed term sheet we provided you all. In addition to the requisite information in the application, the carrier is also required to submit a radio frequency emissions report with calculations prepared in accordance with FCC requirements and demonstrating the small wireless facilities will comply with applicable federal maximum permissible public exposure standards, both at grade and at the nearest occupied structures. So I can't necessarily address the emotional concern that folks may have about this technology and exposure to these wireless waves. But I can say that as part of the deployment, they have to adhere. The wireless carriers would have to adhere to these very specific standards. I'd also just note that the agreement is very specific about the fact that their deployment of these small wireless devices would not cause radio frequency interference with wireless communication facilities or devices, cable television, broadcast radio, or television systems or satellite broadcasting systems, or for our purposes specifically, or police, fire department, emergency operations, shot spotter, walkie-talkie, or other similar systems used in the city at the time of installation. So that doesn't address your primary concern about location next to a school, but two things again. They have to adhere to strict radio frequency standards, and the wireless devices can't interfere with the operations of some critical emergency management equipment that the city has.
Thank you. Mr. Chair, one last follow-up question. On those 30 days that after the sign of the agreement, those 30 days that you mentioned that they have to submit a plan that will most likely have more details about the locations or proposals of locations. During those 30 days, is there an opportunity or is there like a process for either council or the public to have an opportunity to discuss this in a public environment, or this is mostly like this is the plan that we're submitting and then the city will determine the next steps
This is intended to give the city insight into what the plans by the carriers might be, and it's not an application for deployment of these devices. And so it's an opportunity for the city to be able to take this information and then figure out how to make sure that we have the resources in place to oversee and manage it once they make a permit application. Now, they still are all required to make a permit application, and that would go to planning, and it would be a public document. And there would be a public process where there would be an opportunity for citizens to weigh in and say, we have a problem with it because we think that this might materially interfere with vehicular or traffic or pedestrian safety, for example, or something like that.
Thank you. Thank you very much.
Yeah, I would just add on that point. I'm sorry, I didn't mean to interrupt.
No, you can go ahead. Go ahead, Judge. And then
I was going to say one of the important aspects of this agreement, I think, is that it carves out for Hartford the recognition that Hartford has its own zoning process, and therefore it stands apart from the other cities, and the carriers are willing to recognize that and say we'll be part of that process.
And in addition to that, even besides zoning regulations, the carriers still have to get all the necessary permits to be able to deploy a device. So there essentially would be filing a permit application with the city.
Okay, Councilwoman Surgeon.
Thank you, Mr. Chair. Howard, both you and the judge mentioned maybe we have a digital divide, making sure in this agreement there's equitable goals. I just wanted a little more clarification on what those may be. From reading the term sheet, I didn't see anything regarding that information there. If you can point me to that page, that'd be great.
Sure. It's there's actually, I think it's the pages aren't numbered. I apologize.
Yeah.
The second page of the terms and conditions, yeah. Under deployment plans.
Okay.
So the specific language is in the middle of the page, which is bold.
Good faith effort.
Right. You know, as Judge Holzberg pointed out, we don't have the ability under the FCC declaratory ruling to impose this on carriers. But I think we, in the course of the negotiation with the carriers, made it very clear that while it may not be a condition, it is an expectation on the part of the municipalities that they're going to work with us and our respective communities in looking at and considering the notion that this technology should be available to all people in our municipalities, regardless.
I would add to that, if I might, ma'am, that when we were at the governor's office, the president of AT&T was present in the room, as was the chief counsel for Verizon. So that message was delivered repeatedly to them, and they heard that. This was not something that went to a mid-level bureaucrat and yeah, fine. And this has been a theme throughout. I think it's been impressed on the senior leadership up to the C-suite of these two large corporations, how critical and important this is.
So more of, through you, Mr. Chair, of an educating the community regarding this new, 5G network, more than, going into the schools, making sure, that our educational system, is, have the latest 5G ways of getting into the internet. Would those goals be considered equitable goals that we could put on the table, or can we put any equitable goals on the table?
I'm looking for some additional language that I can't find immediately, but I do think we have the opportunity to present to the carriers any goals that the city establishes with respect to equitable access to 5G. But Councilwoman Surgeon, we can't, under the preemption doctrine, impose that as a requirement on the carriers. But both in the statement about working collaboratively or cooperatively towards the goal of bridging the digital divide, if you will, and the carriers committing to a conversation about any plans that a municipality may develop around ensuring that there was equity or no principles of equity, there would be that piece of it. Specifically with respect to using 5G in schools, my own view, and Aaron, you can correct me if I'm offline, but I think what the city of Hartford has been committed to is making sure there's fiber optic internet connection in all of the schools in the city, as opposed to wireless connection. So I think the access to 5G and its potential capabilities is more relevant to individual households and businesses, perhaps, than it is for our education system, at least today.
Yeah, and Howard, I would just also add that you still have to have the fiber as well in order to really make the system work for 5G overall. So your point's well made that I think our focus has been trying to deploy fiber as much as we possibly can in connecting the schools to be able to support the infrastructure for the deployment of 5G and other technologies as they advance. So that really has been the city's focus, particularly as it relates to the neighborhoods and such.
Thank you.
Thanks, Aaron.
Thank you. All right. Any more questions for Howard, Aaron, or Judge Holzberg? Hearing none, the chair will entertain a motion.
I can't make a motion, Mr. Chair, because I'm not a member of the committee.
No, I'm waiting for one of my voting member colleagues.
Finding the mute button sometimes, it's hard. A motion to send this back to council with a favorable recommendation.
Motion's been made by Councilman Hernandez for favorable recommendation. Is there a second?
Second.
There's been a second by Councilwoman Hercules. Any discussion on this item? Any discussion? Hearing or seeing none, all in favor indicate by saying aye.
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 The ayes have it. It's unanimous. This item is passed back to council with a favorable recommendation. Thank you very much.
Thank you.
For your presentation, Judge Holzberg. Thank you very much. You're welcome to stay on if you want to see how we do things here in the committee. But you might have more important things to do with your time.
Well, probably get home to my wife might be amongst them, so I will do that. But thank you. It was a pleasure to meet you, and thank you for listening, and thank you for your consideration.
Likewise, thank you very much, and thank you for your time and your service.
Thank you.
Does that offer apply to me?
Sure, Howard. Well, no, you can't
No,
go.
I'm staying on.
You're the only one for Corporation Counsel.
That's all right. Thank you.
Depending on how long this presentation goes, you could get off in record time. Item number 2 on our agenda is Mayor Brunner with a company resolution authorizing the write-off of the following receivable, which is recorded as receivable in deferred revenue in the city's general ledger, which deals with uncollectible receivables. And we have in our presence, there he is, Julian, our Director of the Office of Management and Budget. You may take it away.
Oh, thank you. Good evening, members of the committee. This is a write-off that's related to some billings for police private duty and fire private duty that date back to July and August of 2019. It's roughly $67,000, split roughly in half between the two, police and fire. The city received no payments on these invoices. Collection efforts continued through 2020 and then into 2021 when the city learned that the company had filed for bankruptcy. And following our revenue policy, the revenue coordinator worked with Corporation Counsel to determine the collectability of the amounts owed, and Corporation Counsel verified that the court had approved the sale of the company's assets to its secured creditors. There's nothing remaining for unsecured creditors, and that the debt could be written off. And so that's where we are today with this write-off proposed to you.
Thank you, Julian. What's the city's policy as to how long we take to try to attempt to collect the monies owed to us before we get to this point of writing off a uncollectible expense?
I don't think the policy specifies a strict timeline. I think it's a good faith effort through our regular invoicing process, followed by maybe a last demand letter or last call letter before sending it to a collection agency. If after attempts by the collection agency, they come back with a recommendation that or advise the city that the that the debt is not likely to be collected that way, then the revenue office would consult with corporation counsel to determine what the next steps would be. So that's typically how it would play out in terms of the sequence of steps. I think this one was delayed somewhat, with turnover in the budget office, and I think it slipped through the cracks last year.
Howard, you had a question?
Only a comment. I mean, I think that defines it well. I'd say two things. One is, in this instance, the debt is uncollectible because of the intervening bankruptcy. So that sort of created we couldn't, it made no sense to wait around any longer to try to collect this. The other thing I'd say is, remember, annually you do the suspense book, which is not a write-off, but rather takes off the books what we think are largely uncollectible debts of the city. But then we spend a considerable amount of time, sometimes years, still trying to collect it. We just don't book it or put it in our accounts as a contingent liability.
Okay, thank you for that explanation. You mentioned that this was private duty. Do you know, particularly back in 2019, was this for a special event that took place?
Well, it was Cirque du Soleil, so I don't
Okay.
remember specifically. I think that was when they were in town. I saw the show, and
Okay,
it was around that time.
I just
Yeah, it was specifically for that, though. When they set up the tent down on Market Street.
yes.
Yeah.
Okay, thank you. Councilwoman Hercules?
Yeah, I just had a quick question, I guess, or a suggestion possibly for events like this. If there could be a budget beforehand for private duty that must be paid before the licensing and all that stuff is given, I think that would avoid us getting in this type of situation where, the business goes out of, goes bankrupt, and then we end up with a pretty hefty bill. I don't know if that has been thought of with, whoever, like maybe licensing, whoever gives these permits, thinking about these type of large scale events and what it would require in terms of officers and to be staffed, and that being a fee, or at least some portion of it being paid before the permits are given.
Yeah, thank you for that. There are some provisions for prepayment in certain circumstances, definitely when it's, someone is in arrears. But I will look at the policy and see if there are ways to maybe make that a little bit more robust.
Councilwoman Sturgeon.
Yeah, thank you, Mr. Chair. Following up on Councilman Hercules' comment regarding payment, individual, when they do hire off-duty, police officers, that payment is normally made, upfront. So are we saying that the policy for a larger, event, that policy may not be there for those large events? So maybe, Julian, you can send us what is the policy for hiring and the payment of, private duty officers?
Yes, I'd be happy to do that.
Okay, thank you.
Any more questions? All right, seeing none, the chair entertain a motion.
Make a motion to send this back to council with a favorable recommendation.
Motion has been made by Councilman Hernandez for the favorable recommendation back to council. Is there a second?
Second.
Yeah, the motion has been made and properly second by Councilwoman Hercules. I'm getting my H's mixed up. Any discussion on this item? Any discussion? Hearing or seeing none, all in favor indicate by saying aye.
Aye.
The ayes have it. It's unanimous. This item is passed back to council with a favorable recommendation. Councilwoman Hercules, I hope that you feel better. Sounds like that you got a little something going on there.
Yes, thank you.
Okay, all right. Since we have no other items to discuss for this committee is now adjourned. Thank you very much for your time and your participation. I'm sorry.
Mr. Chair, don't forget to come back for the public hearing.
Yo, thank you very much. So before you sign off, we do have a public hearing at 7 p.m., which is going to be chaired by no other than Councilwoman Shirley Surgeon. And so she would love to see everyone from the community there. And if you have not done so, you still have time to sign up to speak in favor or against the items that are on our agenda for this evening. So we wish you farewell and have a good evening and stay safe out there. Take care.
Good night.
Thank you.
Good night.